Welcome to Washington Legal Foundation's webinar. I'm Glenn Lammi. I am the Executive Director and Vice President for Legal Studies here. We're very pleased that you've chosen to spend the next hour of your busy day with us. We're also very pleased the court accommodated our unspoken request to complete the term by the end of June, which is always kind of a crapshoot to figure out when the court's going to finish, and don't want to conflict with it with our program, but we have a full discussion of everything that's going on today. It was really quite a sprint to the finish, as it seems to have been for the last several years, full of divided outcomes, one of which stretched to a full amount of 194 pages. Such divisions are naturally the focus of commentary, but it's also important to note that of the 58 signed opinions, i.e. not ones that were per curiam, exactly half, 29, were unanimous, and many of those were actually under 25 pages. That means there's 29 circuit court panels wondering, could we really have been that wrong? As you may know, Washington Legal Foundation is one of the most active amicus filers in the Supreme Court among public interest legal groups. This term was kind of an up and down one for us this year. We supported 6 victories, and the side that we supported lost 6 cases. We supported 21 certiorari petitions during October term 2025, and the court granted 4 of those, which is still a pretty good percentage when you sort of look at the larger picture of how many grants the court issues every year. We filed 4 merits briefs for the cases to be argued next term already, and we'll be doing this sort of a program in September to preview the 2026 term as well. But we're pleased to have you here today, and I'm going to introduce our speakers before we get started. Anthony Dick is a partner with Jones Day in its DC office. Practice focuses on constitutional, appellate, and complex civil litigation. He served as a law clerk for the not retired Justice Samuel Alito and Justice Thomas Griffith of the DC Circuit. Allyson Ho is co-chair of the Nationwide Appellate and Constitutional Law Practice Group at Gibson, Dunn, and Crutcher. She serves as a member of both Washington Legal Foundation's Legal Policy Advisory Board and the Administrative Conference of the United States. She clerked for Justice Sandra Day O'Connor and Fifth Circuit Judge Jacques Wiener. Roman Martinez is global chair of the Supreme Court in appellate practice at Latham and Watkins. He was an assistant to the Solicitor General at the Justice Department, a law clerk to Chief Justice John Roberts, and a law clerk to then Judge Brett Kavanaugh of the DC Circuit. Finally, Zachary Tripp is co-head of the Appeals and Strategic Counseling practice at Weil, Gotshal, and Manges. Prior to joining the firm, Zach served for 5 years as an assistant to the U.S. Solicitor General. He was also special counsel to the Department of Defense's General Counsel and clerked for Judge Amalia Lynn Kearse of the Second Circuit and for Justice Ruth Bader Ginsburg. I want to note that this program is being recorded. If you have any questions, you can use the Q&A function on the Zoom webinar toolbar. And if by chance you're watching this as a recording on YouTube, please like and consider subscribing. So we're going to start off with, I think was one of the most, if not the most anticipated separation of powers decision of the term, Trump v. Slaughter. Allyson, what does the decision mean for agencies like FTC and FCC that have more than one sort of head, and in turn for the business community that they regulate?
Thank you, Glenn. Let me first say I'm so pleased to be here with you today with my fellow panelists. And as a point of personal privilege, I'd like to congratulate you and everyone on the WLF team for another term of gold-plated advocacy at the Supreme Court, and for your equally stellar work in the courts below that marked the path to a lot of these victories this term. And there's none bigger or more historic than Trump versus Slaughter. So in this blockbuster case, the court held unconstitutional the FTC's statutory for-cause removal provision, which purported to allow the president to fire commissioners only for inefficiency, neglect of duty, or malfeasance in office, overruling Humphrey's executor, which for 90 years had upheld the FTC's so-called independence. So every time I use the word independence, you can just read so-called before or put scare quotes around it as you wish. The FTC unquestionably exercises executive power. The Chief Justice wrote for the court and must therefore be controlled by the chief executive, in whom such power is vested. And that landmark decision continues the trajectory of the Supreme Court's recent separation of powers jurisprudence by confirming that Congress may not insulate federal officers of multi-member independent agencies that exercise executive power from at-will presidential removal, even when Congress has historically provided for-cause protections. So agencies like the FTC and the FCC that exercise executive power, a power vested exclusively in the president by Article 2 of the Constitution, must remain accountable to the president. And I think beyond that, to the voters, to the people who elected him. Congress may not enact statutes impeding that accountability. And so one consequence for businesses regulated by agencies like the FTC and the FCC may be increased volatility in administrative policy across presidential administrations, as the president now has broader power to reshape the leadership of former so-called independent agencies more in a real-time way. I do want to draw attention to Justice Gorsuch's concurrence, which should encourage everyone still in the trenches of the war against the administrative state. Justice Gorsuch explained that the decision doesn't eliminate the vast rulemaking and adjudicatory power of federal agencies, but instead relocates those powers in the president. He urged the court to develop and apply its many doctrines designed to protect the Constitution's separation of powers, including the non-delegation doctrine, the major questions doctrine, due process, and vagueness. As Justice Gorsuch put it, the decision, blockbuster though it is, takes a notable step toward the Constitution, but there are still miles to go before we can return to the Constitution all the way.
Anthony, I want to go around and get everybody's thoughts on this case just because of how important it is. So Anthony, why don't you, if you could go first.
Sure. Yeah, no, I think that was a great summary by Allyson. I guess the thing that I would add is that, the bottom line result here was something that I think most people expected. And the big question to me, at least, and I think to many others, was whether the court would go the full distance and say Humphrey's executor is formally overruled, or whether they would do what they'd done in some of the prior cases and say, Humphreys was limited to the very narrow facts where the agency in question was, by hypothesis of the court, not exercising any executive power. And so we're going to limit, Humphreys to its facts and just say it applies only to hypothetical agencies like that exercise no executive power. And here, the agency in question does. So you cannot justify the removal restriction here. So I think it's significant, especially, in light of the broader theme that we'll talk about maybe in connection with some of the other cases of to what extent is this a minimalist or a maximalist court, that here you had the court deciding, to overrule a precedent, to eliminate any doubt that this type of insulation of core executive functions is just not okay, and not to leave Humphrey's executor around to cause any more mischief than it already has.
Zach?
I don't want to get too far ahead of the next question, but I think the most interesting thing about the decision, of course, is the corresponding decision upholding the independence of the Fed, right? So you have this resounding, very strongly worded going all the way to overrule Humphrey's executor and talk about the importance of basically complete presidential control over the executive branch. And then there's essentially this very important asterisk for the Fed because of its unusual historical pedigree. But I think it's really interesting reading them side by side. I think one of the things I was a little surprised by is that they don't talk about each other all that much, right? The two decisions, there seems, even though they come out on the same day, both written by the chief, there's less interaction between the two opinions as I thought there might have been.
Thanks, Zach. Roman?
Yeah, I'll just pick up on a point that I think Allyson made, that, businesses could be in a more volatile regulatory enforcement type environment as a result of the decision. I think the decision is correct as a matter of separation of powers law and the Constitution. But if you're looking at it just purely from a business perspective, you have different administrations with different priorities that come in, and the side that you like doesn't always happen to win the presidency. And so when the other side wins, this is going to empower a president to basically, it's going to make it easier for the president to control the executive branch and effectuate his or her policy agenda, quickly and efficiently with direct control of subordinates and no purported independence. I think that this could cut both ways for businesses, frankly, because, just go back to the Humphreys Executor case that was overruled. Humphreys Executor, it presented politically sort of the opposite situation that arguably you have now. There you had FDR come into office and have a very progressive New Deal program that he wanted to effectuate, and he was stymied in part by Mr. Humphreys, who was the FTC commissioner, who thought the FTC was, as the chief's opinion says, a bureaucracy gone insane and propagating socialism. And so there, the sort of deregulatory move would have been in some ways to protect this pro business anti-New Deal commissioner. And so I think it's really important to realize, although given the current politics and President Trump's current administration, I think this is probably going to be good for businesses in the short run. There is some danger that by alleviating some of the checks and balances that independent agencies had in place beforehand, it's possible that when there's an administration that businesses are not that are more pro-regulation, it's not going to be as good. And that's why I think, as was said earlier, in some ways, it's important for this not to be the end of the story. And there needs to be other doctrines that the court has been enthusiastic about, whether it's the major questions doctrine or textualism or overturning deference, that are going to provide some of the checks on executive power that are going to be especially important in a world where the president has more control over his subordinates after slaughter.
So, Ramon, does this affect the structure of agencies like FTC and FCC in terms of 5 commissioners, the other statutory provisions and requirements that apply to how the agencies are staffed and run, or was that sort of?
I don't think directly. I mean, you can imagine follow-on challenges, sort of challenging aspects of the laws that require, partisan balance or require, multi-member commissioners, maybe. I think those are in a different category, and I don't think that they're directly implicated here. But the whole reason you have some of those sort of internal checks and balances built into those agencies, it's sort of premised on a world in which the president doesn't have the ability to have total control over who's in charge. And so once you give him that ability, then if the president can just fire the Democratic commissioners or fire the Republican commissioners, then some of those internal checks and balances that were set up, have much less oomph in practice and much less ability to actually constrain a president who wants to go all the way to the right or to the left.
Right. So the other separation of powers cases together were the 2 tariff cases that known as Learning Resources. There you had Justice Barrett, Justice Gorsuch were sparring over what the major questions doctrine means. You had the 3 more liberal justices refusing to sign on to anything major questions related. And then Justice Kavanaugh, who definitely seems to be a fan of the major questions doctrine, dissented in that case. So, Ramon, is this a bellwether of things to come for this nascent doctrine, or was this just kind of a academic debate among the justices?
Yeah, well, I think that these cases are all interrelated, and I'm curious also to hear Anthony's take on how Cook plays into all this. But let me just say on the tariffs case, a couple things. Number one, I think this case is a huge deal because it's really the Supreme Court overturning a president's major policy initiative and almost the thing that was the centerpiece of his campaign. And if you just sort of step back and look at the kind of interbranch politics here, that's a big deal for the court to say no. And a lot of people have been criticizing the current court as not being sufficiently independent of this president, which I didn't think was fair at the time. But I think this decision is sort of exhibit A in the case against that view. I think you have a majority coalition that encompassed the chief, 2 of President Trump's own appointees, and then the Democratic appointees saying no to the president on an issue of major importance, on which, by the way, there were reasonable grounds of disagreement. Now, I filed a brief for the Chamber of Commerce opposing the tariffs, but Judge Taranto, who's a Democratic appointee in the federal circuit, had upheld the tariffs. Justice Kavanaugh had a very strong dissent. This was this was not like a slam dunk either way. I think it was a tricky case. I do think that it shows that the court doctrinally is very committed to the major questions doctrine, and that it's willing to apply that doctrine to initiatives from the right as well as initiatives from the left. We saw the doctrine invoked multiple times against President Biden's administration, and here on an issue that it's hard to imagine what President Trump cares more about than tariffs. They applied it here. I think one thing that was interesting, there is an ongoing conversation among the justices about what the doctrine is exactly and how it works. Justice Gorsuch, I think the majority opinion was something like 20 odd pages. Justice Gorsuch filed wrote a concurring opinion that was maybe twice or even more than that as long, essentially responding to almost every other justice on the court and explaining why his vision of the doctrine was correct and why they were either misunderstanding it or should overcome their objections to it. So I don't think that conversation is over, but I think with respect to the major questions doctrine, it's a sign that the doctrine has staying power and is something that has been and will continue to be invoked against presidents of both parties.
Thanks, Ramon, and thank you for reminding me that I jumped over a question for Anthony, which is sort of where are things going to go from this point with the Lisa Cook case now that the court issued its opinion allowing the case to go forward and for her to stay in her position for now.
Thank you, Glenn. I think the first thing to recognize about the Cook case is that the court thought it was really very important to simultaneously indicate that it was upholding the removal restriction on the Federal Reserve at the same time that it was announcing the very broad rule of executive control in slaughter. And I've been told that when the court handed out the physical copies of those opinions, they were actually rubber banded together at the court. So that's hearsay. I wasn't there for it, but I think underscores that the court really saw these as companion cases. For quite some time, the court has been indicating that it thought the Fed is unique. And so as Zach mentioned, one of the puzzles here is that after the sort of resounding rule announced in slaughter that the executive power is vested in the president, and that the president therefore needs to control and be able to remove subordinates, there is this exception for the Federal Reserve, which is, a federal executive agency that the court has now said is an exception, that there can be for-cause removal restrictions. And one interesting thing about the case is that the Trump administration, I think probably recognizing that the court was reluctant to make the Federal Reserve governors removable at will, the government was not even arguing in this case that the removal restriction was invalid. They just argued that they could satisfy the for-cause removal standard in this case. And so in rejecting that position, the court went farther than some of the dissenting justices thought it should have and actually pronounced on the constitutionality of that removal restriction. So I think illustrating again, the court thought it was very important to make clear that, that slaughter was not undermining the independence of the Fed. And how did the court justify this? Well, it talks about the historical tradition of the independent regulation of monetary policy going all the way back to the first and second national banks of the United States, and even before that with the predecessor. And so it says basically, as the court has done in some other areas, that history and tradition can provide its own sort of exception to what otherwise might be a general rule. And I think the court made very clear that this is limited only to the Fed. And then the question that I think is most interesting coming out of this is one pointed out by Justice Barrett in her dissent. So, she said that the court shouldn't have gone so far and resolved this sweeping constitutional issue. But then she also noted at the end that, the Fed not only regulates monetary policy, but it also has some other executive enforcement powers. And the court, in its majority opinion, does not really address how those work. It says that Congress may not add additional powers that are attenuated from the regulation of monetary policy. But what about some of the existing executive enforcement powers? As Justice Barrett says in her dissent, are those grandfathered in? Could those be challenged? And I think that is going to be something you may see come up when the Fed in the future tries to exercise some of those powers, that people may try to raise the argument that that's, too attenuated from monetary policy. And if it's going after in executive enforcement actions without executive control, what are the limits on that? And is that, going to be something the court is interested in policing in the future?
Thank you, Anthony. So the issue of federal versus state courts was a really interesting theme in this term in sort of two different areas, and we'll address both of those. The first was federal preemption. In the most watch of the three decisions in that area, Monsanto versus Durnell, all but two of the justices agreed that federal law trumped state product liability claims against Monsanto for allegedly causing cancer through its ingredient glyphosate. Zach, was the outcome really as obvious as that, as the 7-2 vote seemed to relate?
Yeah, a couple thoughts about that, but maybe just to take one step back. I think in most terms, if we were doing this conversation, this would be like the number one biggest business case of the year. This is a massive whopper decision, knocking out billions of dollars of liability for a major business and like a whole line of argument that plaintiffs have been making for years. And here it's like, I think, a distant fourth behind tariffs, independent agencies, and the Fed, which are these sort of much cross-cutting, massive decisions implicating the business community. So it's interesting that it's even the sort of decision we're talking about in this position. I think a lot of the time, honestly, when there's a Supreme Court decision, even if it's fairly lopsided, the question is close, but then the court coalesces around sort of one side rather than the other. Sort of by definition, most of the arguments that come to the court have strong arguments on both sides. And in this one, I think there's like a high level view of this, which is super simple in terms of the preemption analysis. And I just got to quote this because it's so clear. It's the statute has labeling requirements for pesticides, and then it has a section titled, quote, uniformity, and a state, quote, shall not impose any requirement for labeling in addition to or different from those required under this subchapter. And then a state jury was saying that there needed to be a cancer warning that the EPA had not put on the label. And it's just like obviously in addition to. And so at some level, it feels like it could be very, very lopsided. The thing that I think made this case hard was that the provision went on. There was another provision that said that registration of a pesticide with the EPA is not a defense, and that it's, quote, only prima facie evidence that the label is compliant in a misbranding action. And so there was this sort of language further in the statute that could be read to undercut the force of this very broad preemption argument. And I think ultimately the court coalesced around the rule that if you read that as basically eliminating preemption, then the preemption clause, which I just read to you, would effectively be completely neutered, and the sort of the uniformity that Congress was looking for would effectively just become would become ineffective. I think it's also interesting in this case that Justice Thomas wrote a concurrence. He joined the majority because he's a major preemption skeptic, and he went on to say basically that he thinks this scheme is basically unconstitutional in several different ways, that it exceeds the Commerce Clause, and that basically the EPA can't preempt anything. But he still went along with the concurrence. But you could have imagined also a version of this where he went with the dissent, right, where he had gone 6-3. He's often in play in the preemption cases.
So the other two cases rejected preemption. One was Henselia versus Fluor, that 6-3 decision with a pretty interesting voting lineup. Anthony, how was that case different from Durnell, and do those differences explain the different outcomes?
Yeah, well, I think what Hensley or Henselia, I'm not sure how to pronounce it, really underscores is kind of the doctrinal difference that this court tends to follow and uphold between express and implied preemption cases. So in Monsanto, you had the very clear, or at least very textually grounded preemption clause that Zach quoted. In Hensley, you didn't have that. You instead had this implied preemption doctrine that rests on the more amorphous idea of when state law conflicts with a federal policy or federal interest. So what Hensley was about was a negligent supervision claim against a private military defense contractor that was operating on Bagram Air Force Base in Afghanistan. And the claim was that the contractor was negligent in supervising someone it had hired who was a local Afghan to work on the military base, who, on tragic facts, carried out a suicide bombing that killed several American service members and injured another who was the plaintiff. And the question was whether that claim against the military contractor was preempted, not because of any sort of express preemption clause or statute, but because that state law claim conflicted with the federal interest or federal policy in basically conducting operations there on the military base. Obviously, a very strong federal interest. And so that defense arose under this previous case called Boyle, which was about the preemption of claims regarding military procurement. So in that case, it had been a helicopter crash, and there was a claim that the helicopter was defective in its design. And the court said that claim was preempted because the helicopter was ordered by the military. And so when the federal government orders a military helicopter or other military equipment, you can't bring a state law claim saying that the equipment is defective, contrary to what the federal military contract had called for, because that would be directly contrary to the federal interest. So the court in Hensley reads that brand of preemption fairly narrowly, I think reflecting how the court has been just increasingly skeptical of implied preemption claims, and says that unlike in that Boyle case where there was a direct conflict between military procurement, we want this type of helicopter, and a state law claim saying the helicopter should have been different. In this case, there was a claim of negligent supervision where they're not saying that the contractor should have done anything different from what the military requested or required. It's not as if the military had said that the supervision and hiring of this person had to be done in exactly the way it was done. Instead, the argument was it was negligent, it was not done even up to the standards that the military itself had allowed. And so the court says there's nothing inconsistent in allowing a claim against the military contractor when they're not even saying the military contractor should have done anything different than what the federal government itself wanted. So I think just the broad takeaway here is that the court is increasingly skeptical of implied preemption doctrines. It's going to tend to read them narrowly, in some cases at least, maybe not in all cases, but in many cases. And so, when possible, you want to try to tie yourself to the text of a preemption clause.
The other preemption case was Caribe Transport, and that was one where that was one of the court's unanimous opinions. Ramon, you did an amicus brief for Amazon in that case. WLF filed a brief supporting the company as well. Why was that come such a lopsided outcome? Oh, you're on mute.
Sorry about that. I think the explanation probably ties in with some of the points that both Zach and Anthony have been making, which is that a lot of the preemption doctrine, I think, is driven by a commitment to textualism. And the more conservative justices, they're deciding their approach on preemption in part by looking to the text of the federal statute and trying to think through like exactly what it says, and is it really preemptive, or is this just a claim of preemption based on sort of purposes and objectives or implications as opposed to text. And so here, unfortunately, because as you said, Glenn, we were on the other side of this with together with you all as amici. The court basically looked at this statute. The statute is the Federal Aviation Administration Authorization Act, the F-Quad A, 4 A, or whatever they call it, which has an express preemption provision. And the question was whether that express preemption provision preempted state tort claims alleging that a transportation broker negligently chose a particular motor carrier to deliver shipments. And so basically you have these brokers that help companies that are sending goods to customers figure out how to get the goods from point A to point B. The brokers are researching and connecting the shippers to a particular motor carrier that then carry the goods. And there are a lot of these state tort lawsuits that have popped up saying that the brokers, who tend to have deeper pockets than the motor carriers themselves, negligently chose a motor carrier so that when there's an accident, the brokers end up getting sued. And here the court said there was no preemption, even though there was an express preemption clause, because there was another provision that limited the scope of the express preemption provision. And so the court pointed to the savings clause, which said that the preemption provision, quote, shall not restrict the safety regulatory authority of a state with respect to motor vehicles. And so that was like clear text, the court concluded, carving out a certain type of state safety regulation from the preemption provision. And so the parties argued about whether that state safety regulatory authority that was preserved, whether that applied just to the motor carriers or whether it applied to brokers as well, who, of course, were not operating motor vehicles themselves. And the court basically says that that, when the state tort laws are trying to promote safety by inflicting, liability on the brokers, then those are safety regulations, and they are with respect to motor vehicles. And so I think what explained that decision, and the fact that it was quite short, I think only 8 or 9 pages long and unanimous, was that the court found a textual hook to say that these particular claims were not preempted. And I think that's sort of generally consistent with, at least methodologically, although, again, we think they reached the wrong outcome here, but it's methodologically consistent with how the court is looking at preemption generally, through a very textualist lens.
So Zach very astutely noted that Justice Thomas has always been somewhat skeptical, if not very skeptical, of preemption in general. So Justice Gorsuch was on the side against preemption in every one of these cases so far. Is he sort of the new Thomas on this issue, Roman?
I think he's with Justice Thomas to a very large extent. They were on opposite sides of the Monsanto case, where Justice Gorsuch joined Justice Jackson's dissent. It was a 7-2 decision. And so in that sense, maybe Justice Gorsuch is slightly, more skeptical of preemption, or at least that's the evidence we have from this past term. But I kind of put both of them in a very similar category, which is that, their views on preemption are driven by substantive commitments to textualism and to a certain extent to a vision of the limited role of federal administrative agencies. And they're going to be reluctant to find preemption based on things that are not very closely grounded in the text. And we've seen that in separate writings that those two justices have either written or joined in recent years. I'm not sure we got like a ton of additional sort of data from this term, other than the fact that, as you said, Justice Gorsuch was against preemption in all 3 cases and Justice Thomas in 2 of them. But both of them, I think, are skeptical of looking to implications, looking to sort of general federal policies, to purposes, to objectives. If they're going to preempt a state law, they're going to want to have it grounded in federal statutory text.
So I mentioned that there were sort of 2 areas where federal versus state courts were in play this term. The second one was where cases belong, either in federal or in state court. That came up in Plaquemine Parish, Haines Celestial, and to some extent, the Enbridge Energy case, and First Choice versus Davenport. So Allyson, is there a common sort of doctrinal thread here that emerges from these decisions, or are these more sort of case by case by the court?
Glenn, I think these 4 decisions may reflect 2 sides of the same coin when it comes to federal court versus state court. And just to recap, on one hand, the court opened the federal courthouse doors in Plaquemine Parish, which allowed removal of an environmental suit to federal court under the federal officer removal statute, and in First Choice, which held that the plaintiff had Article 3 standing to challenge a New Jersey subpoena in federal court based on a First Amendment injury. And just as a sidebar on this, I think First Choice may be one of the biggest sleeper decisions of the term for businesses, because even though it didn't arise in the business context, it recognized the threat that can be posed by state attorneys general investigations, which businesses increasingly face, right, from states at both ends of the ideological spectrum. And I think the court recognizing the need for the federal courthouse doors to be open when those investigations cross federal constitutional lines. Again, this is one of those cases, I think, like Zach said about Monsanto, which if we didn't have the blockbusters, we'd be spending more time maybe talking about First Choice. And I think it's a really important decision for businesses facing AG investigations across the nation. So on the other hand, the court issued sort of one-way tickets back to state court in Haines Celestial, which held that when the Court of Appeals reversed the dismissal of a diversity-destroying defendant, complete diversity collapsed and vacator of the judgment in the remaining defendant's favor was required. And in Enbridge, which held there's no equitable tolling of the 30-day removal deadline. I think if there's a through line here, Glenn, it's that, rules are rules, plain text is plain text, and courts really shouldn't have a thumb on the scale either way. So whereas in Plaquemine Parish, the statutory language setting out the conditions for removal is broad and expansive, courts shouldn't adopt constructions that artificially narrow or limit that broad language, and where, as in first choice, there's a well-established doctrinal foundation for permitting access to federal courts, courts should apply that doctrine straightforwardly and keep the federal courthouse doors open.
Thanks, Allyson. The court returned to the issue of arbitration, as it seems to, just about every term. And again, the issue of which workers are, quote, engaged in interstate commerce under the Federal Arbitration Act. Zach, why didn't this one go so well for Flowers Foods, which was the petitioner in this case, and the business community in general?
Yeah, I think that's been actually for the last couple of them a little bit of a trend in the arbitration cases, which breaks from what it had been for a long time. To recap the decision, this is one where Flowers Foods, who are basically the makers of Wonder Bread, have a complicated distribution system where basically they just ship the bread to warehouses, and then there's local distributors who take it from warehouses to grocery stores. And the question was whether the people who drove the trucks taken on the local distribution leg were engaged in interstate commerce or not. And because there's an exception to the Federal Arbitration Act, so it does not apply to seamen, railway workers, and workers who are engaged in interstate commerce. And I think one of the things that was hard for Flowers Foods in this case is that I think they were trying to tee up like a very bright line rule about what qualified as interstate commerce. And if you look back in like 1920, at the time Congress enacted the FAA, the line between interstate commerce and intrastate is very different than what it is today, but it was very confusing, or it was highly fact specific, and it depended on distinctions that are not often drawn anymore. And so they were looking for a very bright line rule that you were only engaged in interstate commerce if you were either crossing the border or loading or unloading a vehicle that had crossed the border. So it was like a very clear and narrow conception of interstate commerce. But I think the trick is it didn't, there wasn't like to come back to some of the earlier points, there wasn't really like a textual hook for understanding interstate commerce that narrowly. When that at the time of enactment in particular, there was a sort of a more fluid and fact-intensive understanding of what that might mean. I do think one interesting thing about the decision is that it specifically preserved a couple of other actually bright lines as potential lines. And I know this is litigation I've been working on, where if you have the contract not with an individual but with another corporation, is that a bright line that knocks it out? And another is if the counterparty on the contract actually takes title to the goods, is that something that basically ends the interstate commerce? And so I think this is something where we are likely to see further litigation in the court about where the line is drawn in Section 1. And I think the court was sort of identifying those as possibilities for the future.
I have to imagine that businesses are probably hopeful that they'll come down correctly in the appeals courts, because the U.S. Supreme Court probably is a little bit fatigued with dealing with this issue. So getting it up there might be kind of difficult. So statutory interpretation came into play, and also along with that, whether statutes allow private rights of action. In two cases, FS Credit Opportunities versus Saba Capital and Cisco versus Doe. Interestingly, both were decided 6-3. Both had Justice Barrett writing for the court. Anthony, is it fair to say these decisions are consistent with this Roberts Court's antipathy toward court-created causes of action?
Well, I think that's one way to put it. You could also say that it reflects the court's love and respect for Congress's role in getting to decide when private rights of action are available. And so I think, yes, these cases both strongly confirm that. So just to recap, and then maybe to say a little bit about the takeaways. In the FS Credit case involved the Investment Company Act and whether there could be an implied right of action for contract rescission under that act. So the law prohibits certain types of investment contracts and then says that a court may not deny rescission at the instance of a party for one of these prohibited contracts. And the question is whether that provides an affirmative cause of action that you can go into court and affirmatively sue based on that statute to invalidate a contract, or rather whether that just creates a sort of remedial provision that when there's some other cause of action, like a breach of contract action or a shareholder suit, fiduciary duty, type of claim, whether contract rescission is available in that type of suit. And so what the court does is just very strictly applies its developing line of cases that say when Congress wants to create a private right of action as a freestanding claim that you can go into court with, it needs to speak very clearly. There needs to be very strong, what the court calls rights creating language. And so even though the court recognized there was some force to the argument that by saying, courts can't deny a rescission at the instance of a party, that's not clear enough to say that that's actually creating a cause of action, because there is this possibility that there's other types of litigation that may exist on other claims that you could use these types of remedies, this type of contract rescission remedy for. So I think this just sort of reinforces and deepens that trend that we've seen, that the court wants to say, look, Congress is in charge of when private rights are going to be created, and we don't want to allow courts to go and sort of infer that based on ambiguous language. I would say that the Cisco case goes even farther in that direction, because it doesn't just refuse to extend private rights of action, but actually cuts back quite significantly on the pre-existing framework under the Alien Tort Statute for recognizing private rights of action. So this case, Cisco, was about a claim under the Alien Tort Statute against Cisco, the network technology company, for aiding and abetting alleged violations, human rights violations in China against Falun Gong religious sect members. And to understand the significance of the case, you sort of have to understand the Sosa decision, which this case got back on. So what Sosa had said was that the Alien Tort Statute, which is itself just a jurisdictional statute, allows for courts to create private rights of action for violations of international law norms. And it does that under the court's opinion in Sosa, sort of a very strict framework for recognizing new causes of action, that there have to be, very clear norms of international law that are out there that the court can recognize. And then there have to be very careful prudential considerations for whether courts should create a new cause of action based on those types of international law norms. So what Sosa said was that at the time of enactment, there were at least 3 types of international law violations. So the violation of safe conduct, infringement of rights of ambassadors, and piracy, which are the types of implied cause of action that could be recognized, that could be brought based on international law norms. But it left the door open, as it said, for the possible recognition of new causes of action. And so ever since then, there's just been a flurry of lower court cases recognizing various types of causes of action based on international law norms. And the court has kind of beaten those back piecemeal and has said, we don't want to apply this extraterritorially. We don't want to recognize X, Y, or Z new types of cause of action. But it had never said that we are actually going to draw the line at those 3 original types of claims and not allow the creation of anything more, right? So at issue here, there was this novel type of aiding and abetting claim. One thing the court could have done was just to say, we're not going to allow the recognition of that new type of aiding and abetting claim. But instead, the court went much further and said, we think that no other types of claims should ever be created or implied under the Alien Tort Statute. So we are cutting back on Sosa. We are closing the door, because it's always inappropriate for a court to create that type of implied right of action without congressional authorization. So some would refer to that as the overturning of Sosa. Others would say that's just a faithful application of the limitations Sosa adopted. But I think it's quite clear that it is a big change in the way the Alien Tort Statute can be read and applied in future cases, and I think is quite a significant development, which just continues that trend that we discussed about how the court's very skeptical of these types of implied claims.
So, Roman, is it fair to say that Sosa is now essentially a zombie precedent?
I mean, zombie precedent sort of implies that it's still doing something, like it's still around. And I almost read it, I read it as essentially overturning the part, at least the aspect of Sosa that had given, these ATS claims life, which is the notion that the door was still ajar in some sense, and that there were some claims apart from the 3 historically recognized ones that Anthony just well summarized that might still be brought. And I think the court is very clear. It said that the authority to create these kinds of cause of actions was always described as slight, but now Justice Barrett says in the first paragraph of her opinion, it's more accurately described as non-existent. And I think later she calls it a null set. And so I just don't think that the portion of Sosa that ATS plaintiffs had always glommed onto and tried to kind of expand and urge courts to recognize, cause of action under. I think that's done.
I guess that like sort of like what Zach said about how significant the Durnell decision was in terms of cutting off certain arguments by plaintiffs' lawyers. You have the same thing here with the Alien Tort Statute decision. So that's
that's right. And I think obviously Congress can be more specific. Congress can create rights of action. I think the court recognizes that. But I think sort of stepping back from this, what the court was doing, and again, Anthony alluded to this earlier, is like sort of enforcing a separation of powers type or impulse, or giving effect to that impulse, which is that it's really not the judiciary's job to decide when someone can come in and assert rights in court and have a right of action. Really, that's got to be something that Congress does. And this statute, which is a founding era statute, it's worded in explicitly jurisdictional language. It doesn't seem to be itself sort of creating rights or creating even the right to go to court. It just says that there is jurisdiction to hear these cases, as opposed to saying, what exactly the cases are that can be heard. So anyway, I think the court saw itself as sort of policing the separation of powers here too.
So the AT&T and FCC versus FCC and the Sripetch versus SEC cases, they both attracted really strong business-related amicus support. WLF filed in both, as did the U.S. Chamber of Commerce and others. And given the Roberts Court's recent rulings on administrative authority and administrative adjudication, the outcome in these cases surprised some. It was 9-0 and 8-1, respectively. Allyson, do you think these rulings were sort of attacked back to the middle on this administrative state project that the Roberts Court seemed to have?
In a word, Glenn, no. I don't think that these decisions are wins for agencies, true, but I don't think they mark a retreat in any way from the court's recent administrative law trajectory. And I think that trajectory is really grounded more in fidelity toward the Constitution than any kind of hostility toward agencies as agencies. I think you can see that in the fact that one of the opinions, AT&T versus FCC, was written by the author of Slaughter, of Loper Bright, of Jarkissi Wright, the Chief Justice, kind of the architect of one of the architects of the court's administrative state jurisprudence, and the other, Sripetch versus SEC, by the author of the Slaughter concurrence, Justice Gorsuch, saying that the most consequential, or at least one of the most consequential decisions of the last century is just the beginning of dismantling the administrative state, and that's Justice Gorsuch. So I think that the fact that you had the Chief Justice authoring one and Justice Gorsuch authoring the others, sort of put to rest any notion that we're seeing any kind of retreat here. I think the other thing to note is that it's a mistake to conflate being anti-administrative state with being pro-business. A lot of the times those align, but not always. And I think that these two cases are examples of that. But I do want to highlight that in the SEC case, the court assumed without deciding that disgorgement is an equitable remedy. And so defendants can still challenge SEC disgorgement requests seeking, oftentimes to provide hundreds of millions of dollars in funds to the U.S. Treasury on the ground that they amount to a penalty that implicates Seventh Amendment jury trial concerns. And that was a concern highlighted in Justice Thomas's concurrence. So I think the next chapter of this story has yet to be written, Glenn.
Thanks for that. I think that's a really important nuance to it, and I really appreciate that you mentioned that. I want to remind our viewers that if you do have questions for our speakers, please use the Q&A widget in the Zoom webinar toolbar to ask them. I'm going to ask a couple of questions to finish up here on cases that weren't business cases, but might have some implications for business litigation. One is, Anthony, what impact do you think the court's decision in Louisiana versus Calais is going to have on employment discrimination litigation?
Sure, great question. I know we're running out of time, so I'll try to be brief on this. So the short answer is that I don't think it's going to have any direct doctrinal impact, but it is going to, I think, increase the salience of the tension between sort of disparate impact and disparate treatment claims. And so let me try to briefly say what I mean by that. So Louisiana v. Calais involves the results test of Section 2 of the Voting Rights Act. So this is a requirement of engaging in some race-conscious districting, even when, at least based on past precedent, there was no actual intentional racial discrimination going on. The statute still had been interpreted to require the creation of majority-minority voting districts and to also require some other types of voting measures that were race-conscious to try to avoid what in other contexts might be called disparate impact type, racially disparate effects. So, the court very kind of narrowly read Section 2 in Calais to say that this should only be required when it's very kind of tightly drawn to preventing what would otherwise give rise to an actual inference of discrimination. And what was doing a lot of the work there was the enforcement powers, limiting the Congress to its actual enforcement powers of preventing voting discrimination. So while I don't think that specific doctrinal hook is present in the employment discrimination context, because you don't have the enforcement powers providing the hook for anti-discrimination statutes, what you do have in the employment discrimination context is disparate impact liability requires employers in many cases to think about the racial impact of racially neutral practices, kind of employment tests or other types of employment requirements that might have a disparate effect across racial groups. And so there have been arguments, and you've seen in the past cases like Ricci versus De Stefano, where plaintiffs, or rather defendants mostly, have said that because you're requiring race-conscious action with disparate impact statutes, that is itself an equal protection problem. So I think it's going to arise much more in that direct equal protection type of context. And as Justice Scalia said in his concurrence in Ricci, there's going to be an evil day when the court is going to have to reckon with this tension between disparate impact and disparate treatment constitutional principles. So I think you're going to see employers more likely to raise that argument, and you're going to see courts have to deal with it more. I think a big limiting factor on it might just be when you have these types of cases teed up to a final decision with appellate review, with employers preserving and pressing these types of arguments. But I think it's a very serious issue. It's one that's underscored by the general logic of Calais. So I think you're going to see more and more pushback on that type of disparate impact claim.
I'll put in a pitch for a WLF publication. So we put out a paper not long after Calais came down that talks about how it's might impact challenges to the disparate impact use of a law out in California that's used for employment discrimination litigation, and it's specifically to that law. But certainly, I think that there probably are other laws similar to that in other states, so it might have an impact on the states. So, Zach, the constitutional intelligentsia have been puzzling over the court's decision in a case where you represented the petitioner, Landor versus Louisiana Department of Corrections. Their decision was to bypass a statutory question and decide the case on constitutional grounds. Is that something that future parties or the lawyers can sort of draw from that, not only just in the business context, but in general about the court's decision to set aside constitutional issues over deciding statutory issues, which is what they usually do?
Yeah, I think having lost the case, I think there's obviously lots to puzzle out about the decision. But it is, I mean, we talked today about several other cases where the court sort of went with the bigger rationale instead of the smaller one, right? We saw that in birthright citizenship on independent agencies. They could have just undercut Humphrey's executor. They went all the way and they overruled it. With the Fed, they actually went and said that it's constitutional. Also in a case that Roman argued, they overruled a prior precedent rather than potentially undercutting it. And Cisco versus Doe, I think they've effectively overruled at least part of Sosa, or they sort of seem to be going bigger. And it's a little hard to know like what to make of that as an advocate and whether that's really much of a trend. But I do think it's when there is a sort of a bigger issue that is the thing that is motivating them, that is like driving them to want to get to a result they're willing to go there and they're not going to shy away from it. In Lander, the case that I argued, this is a religious liberty case where I represented a Rastafarian, a guy who'd been wearing his hair long in dreadlocks for literally decades. They were down to his knees. He was in Louisiana prison, and he had with him a copy of a Fifth Circuit decision holding that Rastafarians had the right to wear their hair long in Louisiana prison, protected by a federal statute called RLUIPA. The guards threw the opinion in the trash, strapped him down, and shaved him bald. And the court held that it was unconstitutional to have a damages remedy against the officers who did that. And I think like one of the things that you see in the opinion, at least to me, is there's not much discussion of religious liberty. The whole decision is about spending and about trying to sort of rein in Congress's authority under the spending clause in particular when combined with the necessary and proper clause. And I think, I mean, Allyson mentioned some cases as a potential sleeper. I think this is one that could have very significant sort of downstream impacts just in terms of sort of federalism and the scope of federal power, because so much of federal power is actually achieved through spending legislation. And the court's sort of the majority's understanding of the necessary and proper clause, I think, is considerably narrower than it had articulated in some earlier decisions. And so I think that's a pretty significant step. Yeah. So I can leave it at that. I could talk about this case for a long time.
I imagine you can. Any thoughts from any of the other panelists on that issue, of the spending clause and what that might portend for future litigation? Okay, seeing none, I will move to the question from our one of our panel attendees. So I'd be interested in anyone's take on the fact that Justices Thomas and Alito always voted with Trump on his major cases, and the three liberal justices never did.
I mean, look, I think there's no question that the voting, is polarized, especially at the edges of the court on the right side and on the left side, and that's something that we've seen in prior years. The liberal sort of block on the court is smaller than the 6 Republican appointed justices, but they're also much more cohesive, sort of jurisprudentially. And so, if you look at the voting patterns generally, they tend to vote, together overwhelming majority of the time, especially in big cases. To me, I think in some ways the more interesting sort of thing is looking at, the center of the court broadly defined, and looking at the ways in which you actually saw a lot of different coalitions come out different ways. One thing I like to do at the end of each term is to kind of make a list of what I think of as the most important cases and then sort of see how the voting patterns align. So I made my list a couple nights ago of what I thought were the 17 most important cases. The Chief Justice was in the majority in 17 out of 17 of those cases. The liberal justices were in the majority in 10 out of 17, which, it's a lot lower than the chief, but it's a lot more than you would think that, if you think of the court as being just divided ideologically. Justices Alito and Thomas were in the majority in 11 and 12 of the 17. So they're doing a little bit better than the liberal bloc, but not that much better. And so what you're really seeing, I think, is a court that sort of, there is a very important middle component to it. It's a right of center middle, but it's the chief, it's Kavanaugh, it's Barrett, and sometimes Gorsuch that are really driving the train. I mean, in decision after decision, if you can get a majority of the 3 justices in the middle, you're just going to win. I think that happened in every single case this term, with the exception of 2. If you can win 2 out of 3 of the chief, Kavanaugh and Barrett, you win the case. And then, on the trickier decisions, high-profile decisions, that a lot of the ones we've talking about, it's often a coalition forming between, some of the more liberal justices in the Trump-related cases, and then the chief and one or more of the Trump appointees, also in the middle.
So since we have a few more minutes, I'll offer Allyson and Zach and Anthony an opportunity to sort of mention something that we didn't necessarily get into, or a sort of bigger theme that you might take from this, kind of along the same lines of Ramon just did. Allyson, why don't you go first?
Sure. Well, one thing I want to piggyback on something Anthony said earlier that I was struck by in the slaughter, which I think by any measure is like one of, if not the blockbuster case of the term. I was struck by a line in the Chief Justice's opinion to the effect that, like, if anything is left of Humphrey's executor, the court overruled it, right? And I think we've seen that move in a couple of cases now where the court says, well, it's overruling precedent that's either already on its last legs or, as in one case, it's even already been dead and buried, as the court said in the Coach Kennedy case, right, about the much maligned Establishment Clause precedent in Lemon. So I think even in the cases where the court, is doing something big, like overruling, 90-year-old precedent, I think there is still this sense that it's doing so. There's already been a path toward that moment. So if you'll allow me a very bad pun, Glenn and friends. So often when the court overrules precedent, as it did in Slaughter this term, it's less a slaughter than a death by 1,000 cuts. So I will be keeping my day job, and with that very bad pun, I will yield the floor.
Outstanding pun. It's like a dad joke, but it's a mom joke.
Thank
Anthony?
you.
Yeah, so a lot I could say. One thing I was going to say was just how in multiple cases we saw the court go broader. I think Zach already very helpfully mentioned that. So the other one that I would mention is just a little bit of a surprise in terms of the relation between executive and judicial branch. A lot of people were expecting maybe more fireworks than we got in the wake of the birthright citizenship decision. I guess I haven't checked Twitter in the last couple hours, but I think it's very interesting that the president has seemed to take the end of this term pretty well. I think has focused a lot on the Slaughter decision and how that is, the biggest win for presidential power ever, or however he characterized it. And I think it's just interesting how the president strategically continues to approach his relationship with the court. So that's something that surprised me a little bit, and I think is a healthy development as far as it goes.
Zach?
Yeah, maybe sort of two observations that piggyback on those. One, if you were sort of thinking about the court, it's interesting to me that the Trump administration lost 3 of the 4 biggest cases of the term. They lost tariffs, birthright citizenship, and the Fed. They won Slaughter, so they got one of them. But that's, I think, a pretty sort of significant shit that at least not consistent with, I think, what a lot of people think about the court. I think another thing that is interesting is it seems like the shadow docket has been quieting down. When last year, there was obviously in the first year of the Trump administration, there was an incredible explosion of the use of the shadow docket. And there's sort of a lot of discussion of that and criticism of it. But there's just been fewer of those filings, fewer of the sort of emergency filings, very fast-moving actions, executive actions working their way through the courts. So I'm curious if that will sort of continue at that sort of like slower pace. I'm sure there'll be other upticks. But I think that's a sort of an important change just in the dynamic at the court, because I think that's something that puts a real strain on the court and the relationships between the justices.
Thanks, Zach. Ron, any last thoughts?
No, I'm all good. I hope everyone's looking forward to a fun summer break from the court, and I know the justices are probably glad to have a breather too.
Well, thanks everybody for joining us today online. This will be available as a recorded program a little bit later today. So if you know of anybody that might want to watch it or you'd like to watch it again, it will be available on our website. I want to thank all of our speakers today. It was a bigger panel than we usually have, definitely worth considering the importance of the panel to have it. And I really appreciate each of the panelists keeping their answers rather short and to the point, and it kept us to the hour that we try to strive for doing here at WLF. And I wish everyone a happy 4th and a good rest of the summer.